even if the surviving spouse decides, nope, stepkids haven't been talking to me, haven't been doing anything with me, I'm going to cut them out. Hi, Jeff Marsocci, the Plain English Attorney, and welcome to the video. Today we are going to talk about whether or not stepchildren inherit. This is something that's come up several times with clients over the last few weeks, and it's either they want to include them, exclude them. And this is what I really like about doing estate planning. It's that pretty much you can do whatever you want. There are different consequences for different choices. There's recommendations to keep things easy and simple on the settlement end, but you can pretty much do whatever you want and pick the beneficiaries that you want. So, do the stepkids automatically inherit? Is what the real question is. If you have no estate plan whatsoever, do these stepkids automatically inherit? Now, I'm speaking for North Carolina, but I'm pretty sure it's applicable to the vast majority of states, if not all of them. No, stepchildren do not automatically inherit if you don't have an estate plan. And the fact is, uh, there is no right for them to say, "Oh, I'm a stepchild, you have to give me a share." That's pretty universal. You can cut out anyone you want. They don't have to automatically be included if you do a plan. Otherwise, the one exception is for a spouse. Most states are protective over spouses, and there's a certain share that they must have in a plan. Otherwise, there's a process for them to get access to it. But stepkids are not going to automatically inherit. So, what is the definition in automatic inheritance if you don't have any kind of estate plan? Because, look, let's face it, if you didn't take the time to do a will or a trust or another formal written way of doing an estate plan, you still have an estate plan because the state decides who gets what. And then you don't have any say whatsoever. So these automatic inheritors, if it's at the children level, who counts as a child? They have to be born to you or legally adopted by you, or in the case of fathers and paternity, acknowledged that they are your child, which would kind of come under born to, but if you weren't on the birth certificate, there is a legal process for acknowledgement. It's not just, oh, yes, this is my son or this is my daughter. And that's, oh, they acknowledged it. No, no, no. Legal acknowledgement under the law is a formal process of filing paperwork and stating, yes, this is my child.
If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel.
So, unless it's one of those three cases, stepkids do not automatically inherit under the law. So, when you are putting together a will or a trust, you have to be specific. And there are a couple of ways that we can do this. Now, when we're doing a will or a trust and there are stepchildren involved, now, this happens all the time, where there was some prior relationship, there's a marriage, and now suddenly they want to make sure that all the kids are included. Well, then we will list the children. Here's my children. And for all intents and purposes, under this planning, here are these other children who are stepchildren. They are to be treated as if they were full children throughout these documents. So this just needs to be put in a specific place, and it's look, I'm leaving everything to my spouse, and if they go before me, I'm leaving everything equally to my children. And that definition includes those stepchild or that stepchild. So yeah, that's the way to do it, just generally speaking. If you really want to be specific, include their names, and we often do, especially if we're doing a trust and we're talking about dis- when assets are distributed to them at certain ages or things like that. We are definitely using their names and including them as a child. So it has to be specific. What's fair? Okay, that's another question. And this is something that really does come out. And I often have clients that come in who are just they feel uneasy because they don't know what's fair. And that's preventing them from even coming in for doing the estate plan. And they really shouldn't. So look, it's easy to lay out, here are some different perspectives, the main ones that I've seen. Choose among them or modify it. So don't let the fact that there are stepchildren in the picture make you hesitate to even come in and talk to an estate planning attorney to get this sorted out and to get your actual written plan in place. So, one that I've seen is, well, it's a second marriage, maybe a little later in life. The kids are generally grown, or in some cases, yeah, there were children from both parents who are now getting married, who end up in this relationship. And it's like that Brady Bunch scenario where you've got three from mom, three from dad. They're all living together and growing up. Okay, we want to treat everybody equally. And so that's the way they list it in the plan. It's everything is just divided equally. Well, what if it's a little bit later in life? Because this happens too. Second marriages after the kids are generally grown, now it's a different issue. So there are a couple of ways that my clients handle that. One, we may not do a joint plan. We will do a coordinated plan. So if it's individuals, they're going to have their own revocable living trusts and list out their beneficiaries and how they want things done. And this really does become a better way to do it if it's, well, wait a minute, I've got my assets. I want my assets to go to my kids. You've got your assets. You want your assets to go to your kids. But we want it to be there just in case the surviving spouse ends up needing some of that money. And so, they don't want to just give everything to the spouse, because then all of their assets would end up just going down to the surviving spouse's kids. Okay, so we can list that out. Well, what about if you have joint assets? And the biggest one is real estate. So they may have all of their own investments, retirement accounts, and things like that. And the other spouse has all of their stuff, and that's all separate. But we've got a house and we own it together. Well, then we just move 50% into each trust. And what I generally do in that case, inside the trust, it allows the surviving spouse to live in the house for the remainder of their life before it gets separated out to the children. So it kind of puts at least those joint assets in a bit of a holding pattern to make sure that the surviving spouse is taken care of. Now, what can happen after is they may, do a little bit of trading and, try to buy out so they can get and sell the house or get the rest of that inheritance right away. Or it may be, hey, none of the kids get anything until they're both gone. And now all the assets are held up just to make sure that the surviving spouse is going to be taken care of. That's a very common thing when we have clients getting into second marriages later in life. Another way that we sometimes do it is they're going to coordinate. And this is throwing another thing in there. What if mom has two kids, dad has two kids, and then they have a child together? All right, so each parent has two of their own children, two stepchildren, and a joint child. So it's three children. This is where it gets to be a little more complicated. But if you think it through, trying to figure out what's fair in that scenario. What I often see and do, each child of each parent, they are going to collectively divide everything among all those kids. But each child that's from another relationship, they get one share. Their joint children are going to get twice as much. So in that scenario that I gave you, mom has two kids, dad has two kids, they have one joint child. Well, that's five splits. But well, wait a minute. Their joint child is going to get twice as much. So it's really divided into sixths, but their joint child gets two sixths. Well, wait, why? Why do that? That doesn't sound fair. Well, wait a minute. Each of those children that are a stepchild to one of them, they have another parent that they are very likely going to inherit from. So they're going to inherit something from, quote, those other sides of the family that that joint child is not going to inherit from. Oh, okay. Well, are the numbers going to work out exactly? No, but that's just generally the way things happen when people do their estate planning, at least in the US. They're not including step kids in the planning. So, uh, it's not like, okay, if mom is Jane and her ex husband is Jim, Jim is not going to leave anything to Jane's new husband, John's kids. So that joint child isn't going to receive anything from Jim. So they're kind of making up a little bit the best we can to make sure that it's more fair. And that does mean the joint child gets twice as much in a share as the other kids. So all of this really does need to be put into a solid will, revocable living trust, or other type of plan to make sure that it happens. And you can be as specific as you need to be. All right, let's make it a little more complicated because this actually happens quite a bit in terms of what people want and desire. And it's not as solid. Hey, I need to make sure that my spouse has full access to everything, but I also need a little bit of a safety net to make sure that my kids, meaning the survivor stepkids, don't get cut out, or at least not cut out completely. And we definitely want a joint plan. Well, yeah, this can be done. So let's just take a look at two different options that we can use. And it's primarily with the revocable living trust where this makes a lot more sense. So you have a joint revocable living trust with John and Jane Doe. They each have two kids, and it's all right. We want everything divided equally among those four kids, even though two are Janes and two are Johns. And the survivor has access to everything. All right. What we can do, and it's already built into the trust that we do, it's called a married ABC trust, and really it's a kind of a tax thing. We can enforce this so that when the first spouse passes on, everything in the trust is getting split 50-50. The 50% that was the decedent's 50%. That's kind of locked up a little bit. Surviving spouse doesn't get to make changes to who the beneficiaries are. They can't, just take all the money out and do whatever they want with it. We put in some restrictions around that so that they're supported. They're going to get all the income, access to use things like real estate and whatnot, but we can limit what they can take out of the principal or make it so that it has to be based on a demonstrated need. So what then happens in that B compartment, it lists the four kids as the beneficiaries. All right. So at the very least, even if the surviving spouse decides, nope, stepkids haven't been talking to me, haven't been doing anything with me, I'm going to cut them out. Well, you can only cut them out of their half. So that's one way to do it. And that's kind of common. Another way, which really is a little more complicated, but definitely doable. In fact, we worked on this just recently with some clients. It's where everything is listed just like that. Okay, everything is going to be equal. And we put in very specific provisions so that if by the time the surviving spouse passes on, if they have changed the beneficiaries away from the first spouse's kids, meaning I'm cutting out the stepkids, I'm just leaving everything to my two kids. Well, now that B trust will recalculate and do everything it can to even it out. So even if Jane Doe was a survivor and she had more money in her A side of the trust and I'm just leaving it to my kids, well, then that would mean everything in the B trust would just go to John's kids. If Jane had less than what was in the B trust, then more would go to John's kids because it's recalculating and doing the math if Jane diverted everything over to those kids. But they'd still get a little something because, again, there were more assets. The math works out, trust me on that. So that's one way to do that is to have these kind of makeup provisions. Now, a very important point when it comes to revocable living trusts and planning, you are not moving retirement accounts into the revocable living trust. And there are tax implications um, however you do this with the beneficiary. So if you're not going to name the surviving spouse as the direct beneficiary on a retirement account, if a big goal is I need to make sure that my kids aren't going to get cut out, well, then either it's going into the revocable living trust after death, which has tax implications. But if it's a large enough size, what we do, we have what we call spousal IRA trusts. Each spouse has their own IRA trust. So the first spouse, again, in this example, John Doe, it goes into his spousal IRA trust. And now we have money that's going to go to the surviving spouse for the remainder of their life, and then go down to those four collective kids. Jane Doe would have hers, and it would go into her trust. But those same makeup provisions that we put between the A and B and that married joint revocable trust, we're going to put them into the IRA trust so it, again, will make up whatever needs to be done and who the beneficiaries are when the second spouse passes on. So when Jane Doe passes on, John Doe's trust is going to do everything it can mathematically to make it equal. And again, it may be cutting out all of Jane Doe's kids if she directed and changed her IRA trust to be it's just my kids. So that's how you can go ahead and recalculate after the first death, but you've got to have that specific good language right there in the trust. All right. So, if you want to get more information on revocable living trust, then please check out the course that we have at freetrustcourse.com. And as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.